How are you this morning?
Good morning. Good. And yourself?
Good, thank you. And let's see. This is NEAL versus State. How much time would you like for rebuttal?
3 minutes, Your Honor.
All right. Whenever you're ready.
May it please the Court. My name is Matthew McLean. I represent the appellant, Antonio Neal, in this case. I'd also like to introduce in the audience is Maura Smith. She's a former judge, and she was the judge who accepted the plea in this case on behalf of Mr. Neal. I'd like to go ahead and address the only issue brought in this appeal, and it's whether the post-conviction court erred by finding no reasonable probability that but for the newly discovered evidence, Neal would not have pleaded guilty and would have insisted on going to trial. The standard that this court and the post-conviction court applied was pronounced in Long v. State, which the Florida Supreme Court said there's two prongs the court has to consider. The first one, is it new evidence? The second one, assuming it is new evidence, is there a reasonable probability that had been known to the defendant at the time of the plea, would he have insisted on going to trial instead of entering the plea in the case? So the court is to look at the totality of the circumstances surrounding the plea when considering whether there's a reasonable probability that they would have insisted on going to trial. I broke the argument section down into two different points. I'd like to start with the second point, because I think it's the most clear reversible error the court committed. The post-conviction court mistakenly found that Neal accepted a favorable 30-year plea offer instead of going to trial and facing life in prison. This is critical. When applying the standard in this case, the court made a critical error, saying that Mr. Neal accepted some benefit by entering a plea in this case, and that's simply not the case. Mr. Neal entered an open plea to two charges, and he faced life in prison. He was at the mercy of the court, and the court ultimately determined that the appropriate sentence was 30 years. There's no benefit that he received by going into entering this plea agreement. And why that's critical is because the court has to consider the totality of circumstances. What's the state of mind of Mr. Neal at the time he's entering this plea? If he did have a 30-year plea offer on the table, then I think this would be a very difficult appeal. This court could say, this is buyer's remorse. He didn't want to enter the plea, but he did get a benefit at the time, and he knew he was getting a 30-year sentence. But there is no buyer's remorse here because he didn't buy anything. He entered an open plea in the case. And also considering the totality of the circumstances surrounding the plea, you have to look at what did Mr. Neal do right after he entered the plea. This is a 17-year-old defendant, and he says, I want to take back my plea. This was before sentencing even occurred, before he knew what he wanted in the case or what he was ultimately going to go ahead and receive in the case. I want to withdraw my plea. That's very important when considering this new evidence that comes into play. His state of mind at the time is, I have no benefit, I'm facing life in prison. Even regardless of this new evidence, I want to withdraw my plea at the time.
How do you confront the the finding made by the trial court that the newly discovered witnesses were simply not credible?
I confront it by looking at, while we can't judge the credibility, this court cannot judge the credibility itself. The credibility, even assuming that they are impeachable witnesses, which is essentially what the state or the court found, these witnesses can be impeached. They're convicted felons. They made an inconsistent statement. They had poor recollection at the time. All those things could be brought up by the state at a new trial, and certainly that is to be considered. But when everything's considered in the totality, this isn't just one witness coming forward saying that Mr. Neal is innocent. These are 6 different people who came and testified on Mr. Neal's behalf saying he's innocent of these crimes.
But of the ones who first spoke about his involvement in the crime, because I know there was the teenager who said he happened to see it and now he's figured it all out. But, Tucker, the woman victim who never testified in court, in this proceeding, she said it was him. The co-defendant said it's him. You have to, in some ways, look right then, the information that's there and available when he's pleading open to the court. How can you say, well, we need a crystal ball and we'll wait 10 years or whatever the time frame is and figure out what it is later?
Well, you look at the evidence at the time he entered the plea. It was Lakeisha Tucker.
Which was he had two people who were involved. One is a co-defendant criminal and one is the victim who said he's the guy, right?
That's correct. You have two people. You have Lakeisha Tucker, and then you have Lawrence Keyes. Lakeisha Tucker went ahead, no prior familiarity with Mr. Neal, but in a photo identification, she said that's the person. And it's well established that photo identifications lineups are not very reliable and often lead to convicting the wrong person.
Well, but that would be a little odd here. I mean, even based on his story, isn't this where he's driving around and they drop 4 guys off and then the other guys are involved in the robbery and your client isn't that's this case, right?
That's correct, yes, Your Honor.
I mean, it seems a little odd that she would just at random pick out somebody that she'd never seen before and who hadn't even been there. And it just so happened that even by his own admission, he was in the car that drops the 4 guys off who ultimately get involved in the skirmish.
Correct. He dropped them off, left, and then unknowingly they committed these crimes.
Wouldn't it seem a little odd that out of all the people in the world that Ms. Tucker would then pick out your client who, at least based on his story, had some tangential involvement?
Well, we don't really know all the circumstances surrounding the photo lineup. We don't know what suggestions perhaps were made by law enforcement. It's simply not on the record. It's very difficult because it was a plea case. This wasn't a trial. So we don't know how this photo identification would have ultimately played out at a trial. What we do know is Lakeisha Tucker, 6 years after the fact, submitted an affidavit that was notarized saying that I was mistaken, I could have been mistaken in my identification of Mr. Neal. That set off Mr. Keyes also being contacted and coming forward and saying, look, I know that I went ahead and made this identification to law enforcement. However, that's not accurate. The people who were involved are 4 different, including himself, are 3 others and himself who committed this crime, and Mr. Neal had nothing to do with it. So is it coincidental that they identified somebody who had dropped them off? Certainly, but we don't know what the surrounding circumstances or the suggestive nature of the photo identification process was in this case. What we do know is that there's significant evidence that's come to light since then that is substantiated. And this court should look at the evidence of Sheena Simpson as well. Sheena Simpson was the catalyst of everybody being implicated in this case. She possessed the victim's property. Law enforcement tracked her down. They said, look, why do you have the victim's property in your possession? Well, I'll tell you that Marvin Griggs, his brother, an individual named Peanut, and Lawrence Keyes came to my house, and they had the property, and they gave it to me. I was DeMario Griggs' girlfriend at the time, and that's how I had the property. Well, when we look at all this new evidence that's come forward, who does it point to? It points to the 4 individuals who came to Simpson's house the day of the crime to give her that property. So when we're looking at the totality of the circumstances in this case, there's significant evidence that all goes together regardless of the credibility determinations. And even if the court were to go ahead and say, these are not credible witnesses, there's problems with their testimony, very well, that's not the standard we're looking at. The standard we're looking at is Mr. Neal, based off the evidence now available to him, is it reasonable that he would have proceeded to trial with this information? And I don't think any reasonable person could disagree that if you had a co-defendant saying it wasn't you, you have a victim, Stephen King, who's come forward, he was also a victim to this case, saying it wasn't him, a teenager coming forward who was present, an eyewitness, saying it wasn't him.
His testimony in part was based on the fact that, this guy's 6'4". Well, how tall was he at the time of the crime? I don't have any idea. So, how does he know that it was or wasn't him? Isn't that something that the judge is supposed to consider? What factual basis does a witness have for saying it wasn't him?
Certainly they can go ahead and consider that, but also considering that you can't consider each witness in a vacuum. You have to consider the totality of all the witnesses coming together. And when you add up all the pieces together, I'd understand if it was just Denard who said, look, I was a teenager, I was there, I went ahead and met him in prison, and I lived in the same complex this crime took place, and it wasn't him. But that's not the case here. If you look at each one in isolation, sure, you could reach that conclusion. It wouldn't be unreasonable to reach that conclusion. But when you're looking at everybody together, the totality of everyone together, it all makes sense, and it all goes back to what Simpson said at the beginning. These 4 people came up to my house and had the victim's property and gave it to me. The same 4 people who are now being implicated. And Marvin Griggs, he was a co-defendant who was charged in this case but never prosecuted. Very lucky that Mr. NEAL received his testimony, because throughout the whole process, the state was saying, look, if you go up there and admit to committing this crime, implicating yourself, which you haven't done to date, this is an offense you could still be convicted of. You could still be prosecuted for. And he went up there and said, I was involved in the crime. Mr. NEAL was not involved. That's very credible evidence that would go to Mr. NEAL's support. And that evidence being available to Mr. NEAL certainly would have advanced the notion that he would have gone to trial in this case. I want to continue to point out this.
Do you view this case as newly discovered evidence, or do you view it as a recantation of earlier evidence?
I think it depends on which witness you're talking about. I think if you're talking about Lawrence Keyes, that's a recantation. He previously went ahead and testified or told law enforcement, according to law enforcement, that Mr. NEAL was involved. Now he's taking that back. But if you look at...
Do you concede that it's within the trial court's purview under the standard of recantation to make a determination as to credibility?
Absolutely. I do agree with that point.
And so I guess,
and that's
at least
why
as to that witness, I'm just wondering, where does that leave us with our ability to maybe disagree, if we were so inclined to disagree with the trial judge?
Well, I think this court would follow the holding in Stills. In Stills, there was a trial court who went ahead and said that this new evidence that came forward, although inconsistent with the testimony of others at trial, was of such a nature that it produced a reasonable probability that this person was innocent, and then went ahead and reversed, going against the trial court's findings. And that's a recent decision out of the first DCA, I believe it was 2016.
Was that a newly discovered evidence or recantation?
It was a newly discovered evidence, but again, we have a mixture in this case. We have recantation and we have newly discovered. We have recantation with Keyes, we have newly discovered with Denard, with King, and with Griggs. Those are...
King, you also have recantation because originally, didn't King said there were 3 assailants and one of them I couldn't see?
You know, in preparing for this oral argument, I looked over the entire record to see where did that come from. Where did he say that there was only 2 to 3 people and he couldn't identify anybody? I couldn't find it in the record. I found it in the record, but it was in the state's closing argument. They just go ahead and make a assertion in the closing argument, not supported by any document, in saying that this is what King originally said. It's not in the record. I should have pointed out in the brief, I missed it, but in preparing, it's nowhere in the record. And you look at the state's answer brief, it's nowhere. In their answer brief, they cite to the state's closing argument. So the court essentially adopted the closing argument, but King was never questioned during the hearing about it. There was never introduction of the statement during the hearing. And if you look at the arrest affidavit that's in the record, there's no mention of King saying 2 to 3 and he didn't see another individual. The only reference in the arrest affidavit is to Tucker saying there's 2 to 3 people. So I don't think that's supported by competent substantial evidence. But again, in addition to the cumulative effect of all this evidence together should result in reversal, the fact that the court made such a critical error in saying that he accepted a negotiated resolution of 30 years, that's cause for reversal as well. And if you notice in the state's answer brief...
Down to a minute if you want to save it.
And I'll just make this one point, and I'll go ahead and say the remainder of my time. The state didn't even respond to that portion that was emphasized in the initial brief. They didn't even mention it. So with that, I'll reserve the last 50 seconds for rebuttal. Thank you.
May it please the court, my name is Pam Kohler. I represent the state of Florida in this appeal. One thing I would take dispute with, that there were 6 witnesses that would testify that the defendant was innocent in this case. That's not what we have here. Lakeisha Tucker has never testified except at the bond hearing, and at that hearing, she testified that she identified the defendant immediately when she was shown, because she was asked, how long did it take for you when you were shown that photo lineup to make an identification? Almost instantly, she responded. He's not the only one I remember, but he's the main one that really sticks out. So for her to...
Did she give a subsequent affidavit?
It was an affidavit, although interestingly enough, it doesn't indicate how she was identified to the notary public. It just said, it's got her signature, but doesn't say if she showed an ID or if she was known to the notary public. And she basically says, I wasn't in the car. I don't think it was the defendant. I mean, she just doesn't sound like she was interested at all in what was going on. And of course, even Keyes admitted that she was kidnapped. She was part of a carjacking. So her statement isn't even consistent with what that was subsequently testified to at the hearing. Okay, so the defendant has shown abuse of discretion. He argues that the trial court found that there's a 30-year plea offer. And that's not really what the trial court, I think, meant to say. I think what he's saying is he entered this plea rather than, which ended up with a 30-year sentence, rather than go to trial where he knows the state would have sought a life sentence.
He had no way of knowing he was going to get the 30-year sentence.
He did not, although his co-defendant got the 30-year sentence. And
He faced life before the plea, he faced life after the plea.
true, although this judge had apparently said that she was receptive to a youthful offender sentence, and they put that actually in the plea agreement as a result, and the state wasn't agreeable with that, but he was allowed to seek that as part of the plea agreement.
He could have done that anyway.
True. And apparently the judge waited until she received the PSI and the PDR, and after that said, well, you've been in trouble a lot as a juvenile. I'm not going to give you a youthful offender sentence at this point in time. As far as, the affidavit, let's see, King. Another thing that I find curious, Lawrence King, or Stephen King must have been shown the lineups, and while there's nothing in the record, that's why I find that his testimony is so incredible as far as he claims that this defendant was not there, that allegedly he had identified 2 of the 3 before, or could identify 2 of the 3 before, but it wasn't the defendant. Now he's saying there were 4 and the defendant was definitely not one of them. Again, I'm not quite sure what's going on with Mr. King. There's nothing much in the affidavit for the arrest warrant in this case as far as what he specifically stated, but I don't know. I just think that he probably could have been impeached later on, that he had seen the lineups like the other victim, Ms. Tucker. And as far as how Mr. Neal's name came about is because Lawrence Keyes is the one who identified him. He's the one that said, oh, by the way, Mr. Neal was involved. They put Mr. Neal and Mr. Mitchell, which are the 2 witnesses, 2 other witnesses or co-defendants that Mr. Keyes had identified, and they showed them to Ms. Tucker, and she immediately identified the defendant. Oh yeah, he's the one who drove me. He's the one in the car, right away, and could not identify Mr. Mitchell, and so that's why Mr. Mitchell never got charged in this crime. So it's the likelihood that now Mr. Keyes can come back and say, no, he wasn't there, when the state would then be allowed to introduce his prior inconsistent statement, which said that he was there, and then it's consistent with Ms. Tucker's statement that he was the one who actually was in the car with her. Again, it's not very credible at this point. And what you would find out is that the jury would be sitting there wondering why the defendant was having all these witnesses lie for him. And, the only conclusion is because he committed the crime. And I just wanted to point out,
Do you view this as a recantation or a newly discovered evidence, or is it, as counsel says, a bit of both?
It's a bit of both, because recantations are generally found to be newly discovered evidence if someone recants more than 2 years.
To what extent, if any, is the determination that the trial court made of credibility significant as far as the newly discovered evidence aspect?
It has a lot. I mean, obviously, if the judge isn't buying the testimony of these witnesses, it's unlikely that a jury would, and that the defendant would have risked going to trial when the state had said, oh, we are seeking a life sentence if you go to trial. And we're not dropping those 2 charges. So I think the fact, they didn't want to maybe put the victim through it. I mean, a jury would have then...
Isn't the standard whether, in light of the evidence, whether the defendant probably would have asserted his right to trial versus seeking a plea?
Yes, and one of the things that you're supposed to look at is the plea colloquy in making that determination, or Grosvenor, according to Long. And at the time of his plea, the defendant said, Your Honor, I wish to take the plea. And the judge said, are you ready to do that? He said, I don't want to sign my life away. I don't want to go to trial. I don't want, and then it's unintelligible. So he didn't want to go to trial. He just wasn't ready to plea. At some point, the defense attorney said something about Mr. Meade said, well, I'm comfortable with what he's explained to me that his participation in this crime was. And I mean, nobody in his family, when they testified at the sentencing hearing, said, oh no, oh my God, there's no way he committed this crime or he was there. It was all about, he hung around really bad dudes and they got him in trouble, and because he had a juvenile record. And so nobody really was thinking he was innocent at the time of this plea. And you've got 3 witnesses, I guess, that would have testified, no, he wasn't there, but all of them are just not credible. And again, if Ms. Tucker testifies according to how she did at her bond hearing, and then Mr. Key's testimony would be, of his prior inconsistent statement would be consistent with what she's testifying to. Mr. King, I'm not quite sure, of course, he's a convicted felon now. And again, I just can't believe that they wouldn't have shown him the lineups that were shown to the victim, in this case, Ms. Tucker. So I'm not quite sure if we could have, impeached him with those, but...
The second prong of this analysis, is it an objective test or a subjective test?
It's got to be objective, because, then, of course, every defendant's going to say...
would want a trial. It's whether Mr. NEAL, under these facts, would assert his right to a trial. It's something he wanted to do on at least 2 occasions before he was ever sentenced.
He
so
did.
we already know he was predisposed to want his trial, and now you add on to that, the witnesses are going to recant, the victim might recant. If he knew all this, whether it's true or not, he doesn't know what weight a jury's going to give that or any of that stuff. If he knew that all these witnesses were going to change their story, he already wanted to withdraw his plea and go to trial. Doesn't that factor into whether Mr. NEAL subjectively wanted his trial, or would have had he known this?
Well, the reason he wanted to withdraw his plea initially is because he said, I was promised 10 years, either youthful offender or 10 years. It's not that I didn't do this and I don't want to go to trial because I'm really innocent. It was, I don't want to get more than, I thought I was going to get 10 years. He rejected a plea of 40 years already. And again, all of these witnesses, are very, the fact that it's taken so long for them to come around and change their stories. Miss Lawrence Keyes, he entered a plea back in 2001 and was sentenced. He clearly could have been, they could have obtained his testimony at that time if they had wanted to. So I don't think that he's even meets the first prong, and the judge found he did not. The only one that he found met the first prong of the newly discovered evidence was Mr. Denard. King initially, well, according to them, they initially told the police that they obviously knew about King, they knew about Ms. Simpson, Marvin Griggs. He was relying a lot on Marvin Griggs' testimony. Marvin Griggs couldn't even remember the name, the surname of a cousin he'd known all his life that he purportedly went to get his affidavit signed at the office. So it's kind of like he was all over the place. And Mr. Griggs said that there was only 1 car stolen, whereas everyone else was saying there were 2 cars stolen that night. According to Lawrence Keyes, they had gone to the apartment complex, they had stolen 1 car, the other car left, and then while they were sitting there, they saw the rims, and so that's why they decided to steal Mr. King's car. So Marvin Griggs said there was only 1 stolen car that night, and that was the Stephen King's car. So even his testimony is inconsistent with everybody else's as far as what went down that night. This is a credibility determination. The judge found all the witnesses to be incredible, especially Mr. Denard. It's a long time. All we have is that we know that the victim has testified that she could identify the defendant, who had been coincidentally identified by Lawrence Keyes as one of the participants in this crime. And if this court doesn't have any other questions,
Thank you.
again, you'd have to show an abuse of discretion, and this is not an abuse of discretion. Thank you.
Thank you. May it please the court. Just quickly regarding the factual error the court made, absolutely they determined that there was a 30-year negotiated resolution. Reading from page 713, he would have insisted on going to trial where he faced a potential sentence of life in prison rather than accepting the 30-year plea offer, which will lead to his release while he's still in his 30s. There's no mistake that that was factually incorrect. As far as Judge Harris, you were exactly on point, I believe. He was predisposed to go to trial in this case. As soon as he found out that, hey, look, there was no bargain in this case, I thought I was getting a maximum sentence of 10 years, I want to go ahead and go to trial, even though Lakeisha Tucker and Lawrence Keyes are going to implicate me. Now we have Lawrence Key and Lakeisha Tucker reversing course in this case, and that would result in a reasonable probability that he would insist on going to trial. Thank you very much, and we ask that you reverse.
Thank you both.